Well, like you rightly said, the case was slated today for commencement of trial, and we came to court with 3 witnesses to commence our case, to prove our case. But unfortunately, around 9:20 a.m. this morning, we were served with an application by the learned senior counsel to the defendant, whose purport is that the court should quash the charges. So we were served, and when the case was called, we mentioned to the court that the case is for trial, and they brought it up to the knowledge of the court that they filed a process. For us, it's not something the court ought to have dissipated energy or wasted time, but being a process that has been lawfully filed before the court was of the opinion that we should respond to it formally, and thereafter the court take a decision one way or the other, whether to quash the charge as applied for by the defendants, or the court proceeds with the case. That being the case is adjourned for Thursday, 7th of March, when we'll come and argue on the application whether to quash the charge or not to quash. Well, as far as we are concerned, there is no issue of jurisdiction in the application. The charge before the Honorable Court is on money laundering charges. And every lawyer knows that money laundering cases are tried by the Federal High Court, which endows jurisdiction on the Federal High Court. So I don't know what they have to say about jurisdiction. From what I gleaned from the objections, the grounds of the objection is that we have not made a prima facie case, we have not furnished evidence. This is not the time to call evidence. Proof of evidence is not evidence. It's only when we call evidence before the court and the court assesses the case. And if the court is of the opinion, upon a no-case submission, that no evidence links the accused, or that we have not made out a case, that's when the court will rule. Not that on the basis of what we have filed, you say there's no link to the accused, or that we have not proved a case. You don't prove a case by virtue of proof of evidence. It's only when you call evidence before the court, witnesses testify, and the court assess the viability of the witness evidence and say, no, there's no case. So as far as I'm concerned, there is no ground of jurisdiction in the application they made. But the court will take a decision on that when we argue. Thank you, sir.